Hi there and welcome. Okay, this one unfortunately is going to be a two-parter. It's not how I prefer to do things, but it's kind of unavoidable because it's the only way I am going to be able to be as clear as I can be about where I'm coming from with this and why, and also it's the only way I can be satisfied that the arguments that I will use, especially in part two, are sufficiently tight. The bottom line is when people do come sniping for me, I want them to at least have to work at it. As usual, of course, I will be doing the timeline in the description below, and on this occasion, given that it is a two-parter, I will try to go that extra mile to make the make that timeline as comprehensive as possible, so that you will be able to dip in and dip out of both parts one and two from as informed a position as possible. Okay, so to get into part one now, it is what I'm going to be doing here. I'm going to be basically explaining why I'm angry about the further conviction that Miss Letby had put on her in May of this year, and why you should be angry as well. In part two, I'll be essentially in part one. I'll be giving the intuitive reasons why, like, it shouldn't have happened, and that the actual outcome is frankly a joke. In part two, I will kind of build on that by actually going into the nuts and bolts of the case. I mean, the facts on which the attempted murder charge is built are, you know, it's just a few minutes of events, so to speak. Well, events, yeah. So, and what I'll be doing, I'll be ripping that in part two, ripping that to shreds, using what Dr. Jairam himself, the registrar who assisted him, Dr. James Smith, the designated nurse Joanne Williams, the one who in the first trial was not supposed to be there, in the sense that the information given at the first trial was that Miss Letby was alone in that room with child K. This is a case that we're going to be dealing with, but that was based on the dodgy door swipe data. So the reality being, which came out in 2024, was that Miss Letby was not actually alone in that room. So, as I said, drawing on what those three people said, I'll be basically showing why, in part two, why it doesn't even support a charge, let alone a conviction. Anyway, so getting far into part one, first off, I have to say, of course, as we all know, this week has been easily the best one for the campaign to get Miss Letby out of prison since she was first convicted. For her personally, I suspect it may well be the best week she's had since first being charged more than 4 years ago now. This is all about the judiciary, of course. Now, for the judiciary, the bottom line, not just in this case, but in all that they do, is their own image, and by extension, the image of the state. So I'm hopeful that the prospect of international ridicule at the significant reversal of opinion by the chief medical expert in the overall case, who was never appropriately qualified in the first place, will cause the judiciary to finally identify its own self-interest with allowing Miss Letby's appeal. We wait and see. Even on the best case scenario, though, I think they do allow it, it's going to be a long, slow process stretching off into the medium term. For that reason, we need to continue making efforts, and this is why I'm going back to one of the cases. We need to continue making efforts to grow the numbers of people who no longer believe the prosecution was a safe one, the overall prosecution, by continuing to call to attention any new injustices that we identify in any of the cases. And that's my position here with, as will become clear with this Child K case. Now, it's probably fair to say that last May's retrial was one of those 6 cases which the jury in the original trial had been unable to come to a verdict on, was not a great focus of anyone's attention. For myself, going back to autumn 2023, when it was first announced that it was going to happen, the retrial, it seemed a curiously petty and vindictive waste of money, as the outcome of it, either way, would not affect the overall picture or materially change anything about Miss Letby's situation or public perception of her. My main takeaway from it at the time was that the decision was instructive of just how little the people who run our society actually care about the well-being of ordinary citizens, given that with a new trial 9 months into the future, the parents of the child in question were effectively plunged into a purgatorial limbo for an extra 9 months, in which their efforts to rebuild their lives would obviously be suspended, and as I could see, all for no useful purpose. Of course, I know a little bit more now than I did then. At that time, I was unaware that contempt of court provisions means that the decision to have a retrial kind of triggered automatic reporting restrictions, which basically made the decision to have a retrial the most effective stratagem possible for countering the growing public disquiet of autumn 2023 about the case and the convictions. It stopped the growing public debate questioning the safety of the convictions in its tracks and put it on ice for, 10 months pretty much, till about June of this year. As such, there was in fact a strategic purpose to putting the child's parents through 9 months of extra pain. Although I think you would agree that it tends more to strengthen rather than weaken my original point about the attitude of the people who run our society to ordinary people. My other takeaway at the announcement of the Child K retrial was the tantalizing prospect of the impact on public perception of the overall case if, at that retrial, she was found not guilty. that optimism was based on the exposure of all the science behind the circumstantial convictions of Miss Letby, having been exposed as at best incompetence and at worst disingenuousness and skullduggery by the blog posts on the Science and Trial website in that autumn of 2023. Those blog posts were even, if memory serves me well, many of them, videos were made of them and uploaded to YouTube. So I was of the mind that it was quite this new information of the serious flaws in the scientific basis of the whole thing was quite widespread in society, and as such, yeah, I just didn't see how, especially 9 months further down the line, as I said, I didn't realise that the reporting restrictions meant that the papers couldn't talk about the debate for that period. So anyway, that on that basis, I was, as I said, I was certain that the jury 9 months down the line from autumn 2023 would be very unlikely to find her guilty. I couldn't see it happening. I was obviously naive, as things turned out. I will have more to say about that guilty verdict at the retrial later. Beyond those two reflections, I put the Trial K retrial to the back of my mind without even bothering to refamiliarize myself with the facts of that case, focusing instead on the appeal process, which Benjamin Myers then had just initiated, and also the prospective public inquiry, which I think had just been also announced. Of course, as far as I'm concerned, least said about that thing, soonest mended. Although I do have some thoughts that I want to share about a snippet of witness testimony to the inquiry by or from a couple of pretty much turncoat former colleagues of Miss Letby, that I think most likely I'll make the subject of the next video I do after this two-parter, or certainly it'll be soon. Now, with the shocking and frankly incomprehensible denial of permission to appeal the original convictions, shocking and incomprehensible for me in light of all the stuff which had come out and which was raging on social media in the autumn of 2024, which surely the judge or judges who were going to make that decision must have been aware of. But in any case, they made that decision, and with that, it meant that for me, when the guilty verdict came out in this May, I can't recall whether it was surprising or not, really, but which probably says something, but if it was surprising, it was certainly less of a surprise than it otherwise would have been. Anyway, at the time, I limited myself just to a few YouTube comments, making my disappointment at the outcome known, and left it at that. Now, back in early September of 2023, when I first properly educated myself on the overall case, I had been aware that one charge pertained to a baby which had been so poorly that the decision was ultimately made to turn off life support to allow the child to die. Now, beyond finding a charge in such circumstances a bit off, I didn't dwell on it, as it was also one of those 6 cases on which the jury had not had not reached a verdict, and the trial was obviously over at that point. Long weeks later, when news broke of the retrial, it did not occur to me that said case was the one being revived. As such, in looking over some old material on the overall case I generated months and months ago, in looking over this a few days ago, I was incensed to learn that the extra conviction put on Miss Letby for attempted murder in this May were in fact related to that particular baby. Fair's fair. How can you go after someone for attempted murder of a premature baby who died in such circumstances? This was, for me, the definition of adding insult to injury. Or, to put it another way, of rubbing someone's nose in the fact of your victory over them, your total domination of them. Why couldn't they have had the grace or the decency to have chosen one of the other 5 undecided cases? One of the 5 other undecided cases, rather, because of course there were 6, including this one. Anyway, once the fog of anger receded, the year and a day rule principle of law regarding murders sprang into my mind. A quick Google search will tell you that this year and a day principle was actually repealed or abolished, however you want to phrase it, back in 1996. But the reality is that what really happened in 1996 was that the principle was, I don't know if elevated is the right word, yeah, it'll do, was kind of elevated from common law to statute law, and actually extended, in the sense that up to that point, if an individual had perpetrated an assault on another individual, an assault serious enough to threaten life, but the second individual had survived the assault for a year and a day, the first individual would no longer be liable for murder in the event of the second individual dying. From 1996, though, the situation was based on advances, in science and so on, meaning that it was now possible to objectively kind of establish any kind of link between a subsequent death and a previous assault. It meant they changed it so that there was no time limit. If you like, the common law thing was what you might call a statute of limitation on murder of a year and a day. 1996 kind of like removed that statute of limitation on murder. So, effectively the year and a day rule still exists, but much but extended. So yeah, that principle being in effect, then if Miss Letby's supposed assault on the baby, which supporting a charge of attempted murder, which took place at 3:50 a.m. on the 17th of February of 2016, if the victim then dies, with the victim then dying less than 76 hours later, just literally just over 3 days later, never having been out of hospital, never having a qualitatively different state of health in the period between, why was that subsequent death not allowed to upgrade the attempt murder charge to actual murder. The obvious answer, as I'm sure some of you will have already thought, is that it, it's because it couldn't. If it could, they would have. I mean, with so short a period between the claimed assault and death, if the assault could not support a murder charge, it was obviously particularly weak. If it was that weak, where was the justification, and more importantly, the equity in giving the attempt murder charge a run in the first place? Let alone reviving it after a first jury had rejected it while accepting other charges of similar seriousness. As I kind of read further around things were to get even more surreal, because in my further reading, I then realised that this case was also the one in which the CPS had been forced to admit to misleading the court with the door entry swipe data which first time around, prior to this revelation, had damningly evidenced Miss Letby being alone with the baby when there was in fact another nurse present, that Joanne Williams who I mentioned. This case was also the one where the major piece of evidence, and really pretty much the only piece of evidence, was Dr. Jairam's claim of, almost catching her red-handed. As such, to me, it was all very powerful stuff in Miss Letby's favour, which had me bitterly regretting that it had not been revealed in time for the retrial, which happened in May. Because I only learned about this probably, I don't know, in the summer. Then I read further, and I found out that this new information was revealed in time for the retrial and was in fact disclosed to the court, and the jury still convicted. I'm sorry, but on top of it all being totally insane, this all stinks. August 2023, no verdict. May 2024, with the only change being a significantly weakened prosecution case and admission of error, they managed to secure a guilty verdict. No. Anyway, this is about halfway, so I'm going to stop part one. Part one ends just here. In part two, as I mentioned at the beginning, I'll be picking up on this, going back to basics starting from the principle of what constitutes a criminal attempt, and I will, drawing on what was said in court, utterly demolish any idea that what happened during that night at 3:50 over those few minutes should support a charge, let alone a prosecution, or rather a conviction ultimately. So I hope that's been of interest. I would encourage you to check out part two, because will be some interesting stuff there, and some stuff that will really make you question how some of this stuff really could have happened. And when I say could have happened, I'm talking about the actual prosecution and the convictions, because it, as you'll see in part two, it doesn't even meet the criteria for a criminal attempt. But I'm not gonna get ahead of things here. So as I said, I hope it's been of interest. Thank you for watching, and look out for part two, and thanks for your time.